Brooks Sandwich House murder trial continues today. So much of the focus yesterday shifted to a different homicide. Jurors heard how Stephen Staples and Terry Conner Jr. are now allegedly tied to a double murder that happened on Antondo Avenue 32 days after Scott Brooks was shot. So detectives now say Asa Shannon and Savon Joseph were found dead inside of a car with their homes ransacked. A very unusual situation there. Chief Legal Analyst Clive Rhodes joining us now to talk about all this. Let's just kind of bring everybody up to speed, because this case took a while to get a jury. Once we got a jury, then we had a juror who fell asleep. Then we had a situation yesterday where a woman brought in a gun. That person was arrested. And then we had another unusual situation where a member of the audience was then kicked out. All this now that we have another murder case that's brought into this case, all trying to find out who killed Scott Brooks. Khalif, this is a lot.
It's a whole lot of moving parts, but let's be clear. A lot of those things that happen are outside the scope of the courtroom. I mean, the thing with the woman happened at the door, obviously, didn't make it to the courtroom. But the fireworks are inside the courtroom. It is extremely unusual to see evidence of another homicide being brought in to the current case, which is a homicide as well.
Right.
And I can tell you why. When you're talking about admitting a piece of evidence, the standard is pretty clear. Is it more prejudicial than probative? Is it going to hurt, the basis and the information of the jury to a negative capacity where they won't be able to, look at the facts? And so that's what the standard is. But yesterday, while it was admitted, this was already argued before the jury ever got there. This would have been argued in pretrial, and it was maybe the second day of the pretrial motions. Defense was trying to keep this evidence out. The state's trying to get this evidence in. And so the judge is saying, well, what is the standard? Well, it's 404 character evidence. I have to be able to make a determination. Are you guys proving this for motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident? In this category, it'd probably be motive. It would be like, listen, we believe these guys participated in this Brooks murder. We also believe they participated in this other murder. Both of them have similar facts. We think we should let it in. Defense is saying, hey, they have nothing to do with one another. Why is this coming in? Because if you watch the trial, they are admitting evidence, pictures, and information from that other murder. So if you're the juror, you're sitting there saying, well, is this the actual murder that you're talking about, or is this another murder? That's what defense is arguing, why that piece of evidence should not have been allowed in at all. My
concern, though, is how does that change the juror's opinion as to what's going on? From the prosecution side and also from the defense side, it seems like the prosecution, their strategy now is you're showing there's a pattern here.
I mean, that's exactly what it is. That's why it's character evidence. When I'm going to show that this person, that's why it's admissible. They have a pattern, a history, a motive. Their intent is there, and I'm going to show you some past wrong acts, some past crimes that they've done to strengthen my argument to why this is a bad person. Yes, that is exactly what the state is attempting to do. And defense on the other side, if it wasn't a murder that they were trying to bring in, but if they were just trying to bring in other prior acts, you probably wouldn't have any questions for it. But this, you're going to have some cross-examination questions. Specifically, do you have any investigation with the Brooks murder? That's the first question I'm asking the detective. They asked him that yesterday. He said no. Why? Because I want the jury to know they're bringing in stuff that has nothing to do with this case. You are in panel on this jury to only decide this case. The other things are, I would say, red herrings.
What about appeal?
I mean, this is something that if you're objecting to this will preserve the record for appeal. So as an attorney, it's always your obligation to preserve the record. So if I don't want this piece of evidence in, I'm going to object instantly. The judge may say, well, I'm still letting it in. Next thing I'm going to say is, I want to make sure that my objection's on the record for purposes of appeal. So that whenever this person, say if they are convicted, they can go back and the appellate court can say, hey, the judge let this evidence in and they shouldn't have. And now we'll allow them to have a new case. But if you never appeal, if you never object on the record, then you've lost that opportunity to appeal it later in the road.
And right now, you're looking at Scott Brooks' family now wanting justice, getting some answers. Clive Rhodes, thanks so much. Appreciate it.
Queen City News Plus. Just search Queen City News on your smart TV's app store.